Good morning, everybody. Welcome to the second employment law case update of the year. For those of you who don't know me, I'm Graham Damant. I am a partner in the employment and benefits practice. Once again, for today, we're going to be using the webinar format, which means effectively that you guys are all invisible to us, unfortunately, so we can't see your reactions. You are all on mute. We've disabled your chat function, so you can't chat to us, but you are able to ask us questions in the Q&A box. I will try and monitor the questions as the seminar progresses and choose those that we can try and deal with during the course of the day. I just want to remind you as to what the intention of the employment law updates is that essentially what we found as lawyers is that despite the fact that we've had the Labour Relations Act now in place for 26 years, we find that the law is constantly changing. Every time the Constitutional Court looks at issues that we as lawyers think have already been resolved and finalized, they come up with something completely different. So we have to keep revising our view of the law, and we need to keep you updated as well. But more importantly, what we try to do is choose cases that are practical to you and the kind of issues that you deal with in the workplace. So we try to find matters that you will have to try and deal with on a day-to-day basis. What we've done is we've got a very full program again. We've selected a few cases, as I say, both of importance and topical, and those that will help you. So we're going to talk a bit about COVID. You will have seen a lot in the newspapers about compulsory vaccinations, and we're going to talk about that. And we're going to talk about a couple of COVID cases. Then we're going to deal with some cases of issues that unfortunately are prevalent in the South African workplaces, sexual harassment and violence during the course of strikes. We're going to touch on what happens if your new employer who's taken over your company requires you to speak Mandarin, and what your rights are in those circumstances, and various issues that I think are all very topical to you in the workplace. We're going to kick off with the very topical issue of COVID in the workplace. I've asked Talita Laubscher, who has been helping BUSA to navigate its way through the interactions with the government to deal with COVID. So she's been dealing with all the TERS issues and COVID-related issues. I've asked her to talk about this issue of compulsory vaccinations, and then to go on and just touch on 3 cases where we are dealing with practical issues pertaining to handling COVID in the workplace. Talita, without further ado, can I hand over to you?
Thanks, Graham. Good morning, everyone. Yeah, you would have seen in the media that there are now companies that are saying there's a moral obligation on us. We owe it to colleagues of ours, clients of ours who have passed away of COVID, that all of us are vaccinated. And therefore, if you want to come and work from our premises, you need to be vaccinated. There are 2 companies already that have come out and said that. There's also talk that public amenities may now just be open to vaxxed people. That is not yet determined finally, but the National Command Council is talking about that. And that is really against the backdrop of our ability to vaccinate around 300,000 of people every day, and the numbers have gone down significantly. We are only vaccinating about 200,000 a day, and there's talk again of a 4th wave that is coming in December, and I think the last thing we want is that beaches must be closed again. So there is a very big push now from various parts of society to make sure that people get the vaccine and that we get to a position of herd immunity sooner rather than later. Now, the question of forced or mandatory vaccinations is really one of the areas where you see this balancing of rights happening right in front of you. So it is good to start at the very beginning. That's a very good place to start. And the very good place is the Constitution. Our Constitution guarantees us the right to bodily integrity And essentially that means that a person has the freedom to make decisions about her or his own body and what goes into her or his body. There's also the right to religion. There's the obligation on employers to provide a safe workplace. And there is the right of fair labor practices, which encompasses also the right of employees to insist on a safe workplace. So all of these things get into this pot and needs to be weighed up in a sensible way. So the right to bodily integrity is given effect to in the National Health Act. And that act says that medical treatment may only be administered with the voluntary, informed, and specific consent of the patient. Now, when an employer is saying you must have the vaccine, it takes away that voluntary aspect. No right is absolute, and the National Health Act recognizes that. So in terms of the National Health Act, this right to give informed, voluntary, and specific consent can be limited. You will all be aware that, in some cases, children may need a blood transfusion. The religious beliefs of the parents are such that they refuse that, and interested parties go to the court, and a court order then overrides the parents' religious convictions if the court then says this child needs to get that blood transfusion. So one of the exceptions is where there is a court order. Another exception is where there is legislation permitting the medical treatment. And yet another one is where not having that specific treatment creates a significant risk to public health. So that principle is carried through in the most recent amendments to the Occupational Health and Safety Direction. And that direction says, yes, we recognize your religion, we recognize your bodily integrity, but the employer needs to do a risk assessment and needs to work out in which circumstances employees might be at greater risk of getting COVID-19 and being at higher risk of falling very ill or needing hospitalization or may in fact pass away. And also in which instances are those employees serving the public. So where there are these kinds of workplaces where there is a lot of interaction with fellow employees or with members of the public, the risk of transmission is increased. And in those circumstances, there would be a significant risk to public health, and the employer would be entitled to then require those employees to get the vaccine. Again, it is not absolute. And an employee who has a genuine religious objection or an objection based on their health situation must bring that to the attention of the employer. And the employer then needs to consider that carefully, interrogate it properly. And then, as we all know, dismissal is a matter of last resort. The employer must first see if that employee's beliefs or medical situation cannot be reasonably accommodated in some way. For example, by wearing the N95 surgical mask, or requiring that employee to work from home, or allocating different tasks to that employee. But if those kinds of accommodation measures are not possible, then the employer would be entitled to move to a dismissal. And of course, that dismissal needs to be fair, both substantively and procedurally. So it is important to do that assessment, to look carefully at the categories of employees that may need to get the vaccine. And as I said, where there are a lot of employees together, like in mines, for example, or call centers, or where there's significant interaction with members of the public, public transport, call centers, hospitals, for example, in those circumstances, one can see that there may actually be room for a mandatory policy. Just want to check that I haven't left out anything. Of course, also the employer needs to talk to its employees about this. It needs to engage with the unions, and it needs to educate and encourage employees as far as possible. So that is the broad legal principle, and it will be very interesting to see how these companies who have announced mandatory vaccines, how that will play out, and how objections, genuine objections, will be accommodated. What many employers do is that they say, we are not forcing anybody to get the vaccine, but if you want to work from our premises, you need to have been vaccinated. So the situation of remote work can continue, but the moment you want to come to the office, this is a vaccine zone, a vaxxed zone. So that is interesting. In those circumstances, dismissal wouldn't come into it. The employee will be entitled to work remotely. Bonuses, those things should not be affected. What isn't that clear is how team dynamics might be affected through this, how that might cause issues in the workplace, and how that will be managed. So there are a lot of things to consider, and yeah, it's uncharted waters, and we will see how these things pan out.
So before you go into the cases, just a couple of questions coming up relating to whether you deal with it as an incapacity termination or whether you deal with it as a retrenchment.
Yeah, I think one needs to consider that on a case-by-case basis. I think it will depend on the employee's role, and whether one can say that because you are not vaccinated, you have this contact with the public, you are now incapable of performing the inherent requirements of your job. You need to get the vaccine in order to perform that, and you cannot perform, for example, an employee who is required to travel. The airline is saying, we are not taking passengers who are not vaccinated. The employee refuses, so the employee cannot perform an integral part of their job. I think that is an incapacity. But it is conceivable that there might be circumstances where you would do it as an operational requirement. And then, of course, one needs to then follow the correct process. But it will have to be determined on a case-by-case basis. Then I will move on to the cases, and these are COVID-related cases. We all know the rules. You need to wear your mask. You need to have adequate space. You need to hand sanitize, all of those good things. Some companies already in March last year put in place very strict rules in relation to how these things are going to be handled, and Shoprite Checkers is one of them. They said, if you are awaiting a test result, do not come to work. You are getting a test result for a reason, so stay at home and inform us what that result is, and but do not come to work while you are waiting for that result. So Mrs. Diabela was a fresh food manager at Shoprite. She had been in a role for 8 years. She was a manager. And in May last year already, the company sent this memo in which it sets out all these rules, including the rule that you need to stay away if you are waiting for your test result. On the 28th of December, she came to work, no problem. And at 3 o'clock that afternoon, she got the message on her cell phone saying you tested positive. So she went to the branch manager, told the branch manager that she had gone for the test, and sadly it is positive. And the branch manager, that was at 3 o'clock in the afternoon, the branch manager instructed her to leave immediately. They served all the customers who were in the store, closed the store, got a company in to deep clean, and they sent employees who were in contact with Mrs. Diabela for testing. They sent 11 employees for testing, 6 came back with positive results. So promptly, they instituted disciplinary proceedings against Mrs. Diabela, and she was dismissed. She argued that her dismissal was unfair. She said she had gone to the doctor with a toothache. She wasn't feeling ill at all, and she was advised that she needed an operation and that she needed to have the COVID test as a precautionary measure. So that is why she went to work. Also, she had no knowledge of this rule that you needed to stay away if you were awaiting a test result. She said that memo that was sent in May, no way, she never saw it. It wasn't on the notice board as the company claimed. No, she had no knowledge of that rule. In fact, she had tested negative a previous time and no action was taken against. Unfortunately for her, on the 12th of May 2020, she signed that memo saying that she actually knew these rules, which included the rule to stay away if you were awaiting a test result. And the CCMA then held that it was improbable that she didn't know this rule, that her conduct was reckless, that it contravened not only the employer's rules, but also placed lives at risk, and that dismissal was appropriate because her conduct, even in the arbitration, showed a complete lack of remorse and dishonesty, and her dismissal was therefore held to have been fair. Another case is Mrs. Mutapu. This is Alliance International Medical Services. These are the people who evacuate experts if they need to be evacuated from remote sites and bring them to South Africa or take them to other places for medical treatment. And she was employed on the 8th of June 2017. Again, she was charged with contravening the employer's rules relating to the management of COVID in the workplace. And that related to the period 21st of December last year to the 31st of December. On the 30th of December, Ms. Mutapu came to work and she wasn't feeling well, and she told the manager she wasn't feeling well. He said, go for a test immediately. She went off to Sunninghill Hospital, got a test, and tested positive. It's a small company, so immediately the company took steps to do contact tracing to see with whom Ms. Mutapu was in contact. And by doing that, they looked at CCTV footage, and they saw that Ms. Mutapu wasn't wearing a mask, and she wasn't adhering to the social distancing rules. And in fact, some colleagues had said that she hadn't been feeling well for 3 days before she's told her manager. None of that was recorded on the COVID screening forms, and they accordingly called her to a disciplinary inquiry. So that happened on the 30th of December. She then had to be in mandatory isolation for 10 days. What did the company do? They issue her with a notice to attend the disciplinary hearing on the 6th of January. And the disciplinary inquiry was convened on the 8th. She attended that hearing, but it was still within that 10-day period. So she said, come on, the company itself isn't adhering to the COVID rules by requiring me to come in person to a disciplinary inquiry. And the CCMA agreed. It said there's a valid reason for your dismissal, but the company is not entirely blameless. Yeah. So it said it was procedurally unfair because of the timing of the disciplinary inquiry and the fact that it was held in person, and they awarded 6 months compensation. The last one, Mr. Mobile versus East Coast Board, he didn't like this mask wearing story. And he was constantly either not wearing the mask or wearing it just below the nose, so only covering the mouth. And he was actually given a final written warning in February this year, on the 26th of February. And then promptly 2 weeks later, again, he wasn't wearing his mask and he was dismissed. He took the company to the CCMA. He said, no, this was completely inconsistent treatment. And actually, you know, if the company took this seriously, they would screen us at the gate and they would make sure that when we come in, we are wearing everything properly, you know, no responsibility taken by him individually. And the CCMA had none of that. It said, it's your responsibility. In fact, we are extremely disappointed with how you are conducting yourself, because even at the arbitration, he wasn't wearing this mask properly. And he had to be told to put it over his nose. So the CCMA said, no, there was progressive discipline. They tried to educate and get you in line. He didn't, and that dismissal was held to be substantively fair.
Thanks, Steve. It seems to me then that the courts are going to come down quite hard on employees that don't comply with rules relating to COVID. That seems to be the general trend that I can sort of pick up from the various cases. Two comments that's just coming through from questions. One of the questions is whether you could set aside an area in your workplace for people who refuse to be vaccinated to work away from everybody else. And I think that would be one of the sort of mitigating factors of reasonable accommodation you would have to consider if you go through an incapacity type of hearing. The second issue is, you know, what happens if an employee doesn't disclose to you that they've gone for a test? Again, I think that would be a rule-based issue. You would have to have a rule that says you're obliged to make a disclosure to me in the event that you're going for a test. And it would, again, go to that filling in of forms as well, as to, you know, whether you are required to make that disclosure or not. Thanks very much. Ros, we're going to move on to the strike misconduct cases. So there was you may recall, a recent Constitutional Court case that dealt with the issue of, you know, people being collectively responsible for violence that occurs during a strike. There's an interesting Labour Appeal Court case that has now come up, which Ros is going to touch on. Ros Davey is a partner in our employment and benefits practice, works a lot with the collective strike action and that kind of area as well. Ros, over to you.
Thanks, Graham. Hi, everyone. So the case I'm going to be discussing today is NUMSA on behalf of Lulu and 147 others versus Mali Pipe Systems. Now, this case involves the dismissal of employees for participating in an unprotected strike, as well as a serious assault on a manager that occurred during that unprotected strike. Mali Pipe Systems operates in the plastic industry and forms part of or falls under the jurisdiction of the MEIBC, which is the Metal Engineering Industries Bargaining Council. The collective bargaining in the industry is done at industry level, and for the plastic sector, it's done through the Plastic Negotiating Forum. However, unlike some of the collective agreements, which say that it's the only way, you know, you have to comply completely with the agreement, the MEIBC agreements provide that employers may give different terms or better terms. So if there's a minimum wage set, they can agree to higher wages. Mali Pipes entered into discussions with its employees and offered a 7.5% increase in their wages. This was conditional on the collective agreements that were still being negotiated in the bargaining council. And the company said that in the event that the collective agreement agreed to a higher wage increase, they would comply with the higher wage increase. Their staff were not happy with the proposed offer. On the following day, they reported for work. The workforce, they were all NUMSA members. The workforce downed tools and they left their workstations and went to the canteen. When they were at the canteen, they demanded that the HR manager come and address them because they wanted to understand the attitude of the company in only offering the 7.5% increase. The HR manager did not come to address them at the canteen, and they collectively decided to approach the HR manager's office. At this stage, they were carrying banners and they were verbally demanding the removal of the HR manager, one Mr. Stefan. When they got to Mr. Stefan's office, he came out of the office. Now, I'm not certain if it was to address them or if it was simply to leave, but 12 of the striking employees assaulted him. They were punching him, they threw him to the ground, they kicked him, and ultimately they threw him out of a window and were throwing stones at him. He was quite seriously injured and he was taken to hospital. The SAPS then arrived and they got the employees off site, and the employees then left. Following the incident, there was a Labour Court order interdicting the strike and prohibiting further violence and harassment. And then after this all occurred, Marley Pipes conducted an investigation into the unprotected strike and specifically into the assault on Mr. Stefans. During that investigation, they spoke to eyewitnesses, they had photographic evidence, they had video footage, and they took a decision to charge all employees who were involved in the unprotected strike for both participating in the unprotected strike and for acting with common purpose to assault Mr. Stefan. They identified the employees through their presence at the scene, they associated them with the assault because they were present at the scene. They encouraged the assault. After the assault, they were rejoicing in the assault. They held placards and demanded the removal of Mr. Stefan. And at the disciplinary hearing, all the employees said, we were leaders during this strike. So they all took responsibility for the strike and they didn't distance themselves from the strike. Prior to the disciplinary hearing, and indeed during the disciplinary hearing, employees were given an opportunity to come and state a case and to distance themselves from the conduct on the day. There were a couple of employees who availed themselves of that option and they were not dismissed. The employer accepted their explanation and they weren't dismissed. The remaining employees were dismissed. The matter was then referred to the Bargaining Council and subsequently to the Labour Court as an unfair dismissal. The pleaded case was that the employees did not embark on an unprotected strike and that there was absolutely no assault on Mr. Stevens. The union only led the evidence of one witness, and during that witness's evidence, he confirmed that actually, yes, they did embark on an unprotected strike, but he persisted in the denial that there was an assault on Mr. Stefan. And he said they were in the canteen, they never marched to Mr. Stefan's office and they never assaulted him. The company led evidence to show that they had in fact congregated at the canteen, that they had then all moved collectively to Mr. Stevens' office, and then they showed pictures and video footage of the actual assault that occurred. They had also identified the 12 people who were actually responsible for the assault, and they were also able to identify 97 other employees or strikers who were present when the assault took place. But there was a group of 41 employees where they couldn't actually place them at the scene of the assault through any eyewitness evidence or through video or photographic evidence. What they said was that the inference was that the employees were present there, and in getting to that, they identified that these 41 employees had reported the clocking system to show they'd reported to work on the day. They used the system to show that these employees left their workstations and went to the canteen. They showed that the employees did not remain in the canteen and they did not report back to their workstation. And they said, based on the inference was that these employees were part of the group who were present when the strike, when the assault occurred. There was one employee who was not present. There was a shop steward, and he was not at the premises at the time that the assault took place. However, the employer took a decision to dismiss him as well on the basis that he associated himself with the conduct after the fact. So after the assault took place, he associated himself with that conduct. They were all dismissed, and the Labour Court, having considered the evidence, accepted that there was a mob attack and accepted, based on the principles of common purpose, that all 148 employees, including the shop steward, had associated themselves with the attack. And they looked at the Court decision of Nomsa versus Dunlop Mixing and Technical Services, and they noted that it is unnecessary to prove that each person was on the scene at the time that the assault took place. In order to prove common purpose, you can establish it by inferential reasoning, having regard to the conduct of the employees before, during, or after the misconduct occurred. The Labour Court was then satisfied that the dismissal was fair. In addition, it's interesting that the company had claimed damages in a counterclaim against the union and succeeded and was awarded about 800,000 rands worth of damages. The union then appealed the decision of the Labour Court. Interestingly, they did not appeal the finding on damages, and they only appealed in respect of the shop steward, who wasn't present when the assault took place, and appealed in respect of those 41 employees that the company was unable to physically place at the scene of the assault. The Labour Appeal Court then considered the concept, or the whole idea of common purpose, and it accepted that the Constitutional Court has recognized that employees may participate in and associate with misconduct, both directly and indirectly. But the Constitutional Court has cautioned that no one should be held accountable when no evidence can be adduced to substantiate the claim against the individual. So you need to have some form of evidence that they were present. The Labour Appeal Court then looked at the proven facts and said the proven facts are that all the employees reported for duty, they all embarked on the strike, they all left their workstations, they all went to the canteen, none of them stayed in the canteen, and none of them went back to their workstations. And they said, well, then it gives rise to the inference that the employees were present when the assault took place. The court then said that it is the duty of the court to then select the most probable inference to be drawn from the circumstantial evidence. The court noticed that in this case, the employees didn't put forward any alternative inference. And on that basis, the Labour Appeal Court accepted that the inference drawn was that all the employees had associated themselves with the assault. The court was then satisfied that our law allows for common purpose in the workplace and allows for employees to be held liable for common purpose misconduct. And on that basis, the Labour Appeal Court accepted the Labour Court's finding and was satisfied that it was correct, and is satisfied that all those 41 employees associated with the assault. The Labour Court also accepted that the shop steward had associated himself with the strike and with the assault by the way he conducted himself after the assault took place. So very interesting case there. And I think it shows very clearly that the Labour Court and the Labour Appeal Court are taking the issue of violence and intimidation that seems to be happening more and more often in the workplace and during strikes very, very seriously. And this does make it easier for companies to firmly stop or take action against employees collectively where there is assault, intimidation, and violence during strike action. Thank you.
Ros, I think one of the interesting aspects of that case was the way that the employer went about gathering the evidence, making sure that it did have video evidence, making sure that it was able to show where people were moving during, around the premises during the strike. And I think that just illustrates the importance of keeping logbooks, videoing, photographing, so that you're able to establish this at the end of the day. And I think that that's
Yes.
very important from a strike handling perspective, is the gathering of evidence.
Yeah, and the fact that they went into that significant level of detail when investigating it. They closed the doors, so there was no room for NUMSA and the employees to maneuver and claim that they were not responsible. Yeah,
but I think the importance of it again is the common purpose doctrine, is that people who associate with the violence that's occurring by encouraging it, not stopping it, celebrating it, that kind of thing, are all equally complicit in the misconduct that occurs. And that's been applied in a number of cases for where you've had those cases where there's a small store, 3 employees in it. Somebody steals all the product in that store, there's massive theft, and then they say, oh, we can't prove who did it, but all 3 of you would have known about it or been complicit in it, because 3 of you it couldn't have happened without all 3 of you being involved. And it's that sort of common purpose again, doctrine that goes with that. Thank you. Yeah, so we'll move on to the issue and it's a serious issue and a plague in our workplaces, this issue of sexual harassment. And I'm going to ask Nikita Reddy, who's a senior associate in our Cape Town office, although we don't seem to have we seem to have virtual offices these days, who's in our virtual office, to deal with the Constitutional Court case of McGregor versus Public Health and Social Development case. And it's just interesting to see these cases that involve individuals winding their way all the way through to the Constitutional Court. Thanks, but over to you, Nikita.
Thanks, Graham. Good morning, everyone. Thanks so much for joining us. So the case that I'm discussing today is unfortunately yet another sexual harassment matter involving a very senior male employee in the workplace and a very junior female employee who's about 30 years younger than the perpetrator in this case. This case is not so much about the conduct and whether or not it constituted sexual harassment, but it's more about the award of compensation to the perpetrator, Dr. McGregor, in circumstances where he actually was found to have committed sexual harassment. So in terms of the facts, Dr. McGregor was the head of the Department of Anesthesiology at George Hospital, which is a public hospital falling under the Department of Health in the Western Cape. So he was a very senior employee. And he committed acts of misconduct in the form of sexual harassment against his interns. So his direct report, a female, newly qualified medical practitioner, and he was about 30 years younger than him. He was charged with 4 acts of misconduct that constituted sexual harassment. The first charge is that when Dr. McGregor and his female intern were at an outreach program, he dared her to take off all of her clothes and swim naked. The second charge was also at this outreach program where he made a sexual advance, an unwanted advance towards her and suggested that they have an affair. The third charge happened while back at the hospital, where Dr. McGregor pressed himself against her body in trying to demonstrate how to perform a procedure. And the judgment, unfortunately, doesn't tell us what procedure he was trying to demonstrate. And it's really inconceivable to think of how he thought he might press himself against her to demonstrate how to perform this procedure. And the fourth charge was that he made unwelcome advances towards her while they were driving together, and he inappropriately touched her leg. So Dr. McGregor was charged, he went to a disciplinary hearing, and he was found guilty and dismissed for misconduct and committing sexual harassment. Not surprisingly, Dr. McGregor wasn't happy with this, and he referred an unfair dismissal dispute to the CCMA, and the arbitrator there found that he had actually committed 3 out of the 4 acts or charges of sexual harassment, but somehow still concluded that the dismissal was substantively unfair and procedurally unfair. And the commissioner then decided to award 6 months compensation to Dr. McGregor on this basis, which actually amounted to almost R1 million. And the commissioner found that since he had actually committed 3 out of the 4 charges of sexual harassment, it would be intolerable to reinstate him, and decided to give him that 6 months compensation award instead. Dr. McGregor was still unhappy with this, so he went off to the Labour Court to try and review part of the arbitration award that he didn't agree with. But then the department decided that they would also cross-review and seek to review and set aside portions of the award that they didn't agree with, specifically relating to the conclusion that he hadn't committed the 1 charge of sexual harassment and that the dismissal was substantively unfair and procedurally unfair, and the award of compensation as well. And at the Labour Court, the court said, well, the commissioner got it wrong in the sense that he said that the dismissal was substantively unfair. There's no way that you could have committed 3 out of the 4 acts of sexual harassment and then find that the dismissal is fair. So the Labour Court said no. It varied the arbitration award and said that the dismissal is substantively unfair. However, the Labour Court held that the dismissal was still procedurally unfair and therefore did not vary the compensation award. So now we have a slightly different outcome where the Labour Court said the dismissal was substantively unfair, but in terms of procedure, it's still unfair. And so I'm leaving the award of 6 months compensation intact. Parties went off to the LAC, and the LAC unsurprisingly agreed that the dismissal was substantively fair. But unfortunately, by some error or omission or oversight, the LAC didn't consider the issue of the compensation award. So the department was still sitting with a compensation award of almost R1 million that it needed to pay over to Dr. McGregor, despite the courts now having confirmed that it was actually fair to dismiss him. So that's how the parties ended up in the Constitutional Court in this matter. Dr. McGregor was still trying to appeal against his dismissal, but the Constitutional Court was not entertaining that, said that it's not in the interest of justice for it to reconsider the fairness of his dismissal because it's been fully ventilated throughout the court and it's really just a standard dismissal dispute. So there's no need for the Constitutional Court to intervene there. But where the Concord did intervene was on this question of compensation, and it decided to determine the department's cross-appeal in the Concord. So there the court looked at all of the applicable legal principles to compensation awards in the CCMA. It looked at the provisions of the LRA, which empowers a commissioner to make an award of compensation. And the court said that this is an important legal principle and it goes a long way in protecting employees' rights. However, compensation is never guaranteed. So even if there's unfairness, it's never guaranteed that you will get a compensation award at the CCMA. But the court ultimately agreed with the employer's submissions here that the arbitrator's findings and the award of compensation was actually based on the fact that the commissioner found that the dismissal was both substantively unfair and procedurally unfair. But now the Labour Court and the Labour Appeal Court have confirmed that it is actually substantively fair. So there's really only an issue in terms of procedural fairness. And the court agreed with the employer's submissions that since there's only an issue with procedural fairness, the award of compensation of 6 months should have actually been reduced. So the employer was arguing in the Constitutional Court that he shouldn't get 6 months, but should get less. And the Constitutional Court then considered all of the relevant case law and determined whether or not it was entitled to interfere with the arbitrator's discretion in deciding how much compensation to award. And the court ultimately concluded that it can actually interfere here. And then the court had to decide, well, how much compensation, if anything, should Dr. McGregor get? And it considered quite a few factors, mainly that the procedural unfairness in this matter was really not so significant that it awarded a significant or substantial amount of money to be awarded to him. There were really minor procedural irregularities, although Dr. McGregor really tried to make it seem as though they were really egregious. The court said it's also really important to consider the gravity of the misconduct committed. So of course here sexual harassment is a very, very serious offense. And lastly, the court said you need to consider the appropriateness of compensation in the context of the dismissal dispute. So what did Dr. McGregor actually do? He committed very serious acts of sexual harassment against his subordinate and junior employee 30 years younger than him. And what's interesting about this judgment is that the Crown Court took the time to make some very powerful statements about sexual harassment and gender-based violence in the workplace. And there's quite a long, important passage in the judgment where the court sets out the extent to which sexual harassment actually erodes the dignity of employees in the workplace, and that it actually promotes a culture of gender-based violence. And that is certainly intolerable and completely at odds with our constitution and needs to be eradicated. And the Constitutional Court referred to previous judgments like Campbell Scientific and Gaga, where the courts really analyzed this power dynamic and said that sexual harassment is actually severely aggravated where one experiences it at the hands of one's supervisor. Lastly, the court also noted that in this case, Dr. McGregor showed absolutely no remorse. He continuously sought to undermine and attack his intern throughout the litigation process. And ultimately, the court concluded that it simply cannot allow him to walk away with R1 million in compensation from the public purse, no less, in circumstances where he did, in fact, commit sexual harassment. The court then said it had to take into account that there was an element of procedural fairness. And because there was an element of procedural fairness, it went on to vary the arbitration award and reduced the compensation awarded to him to 2 months as opposed to 6 months. And I think what's important here is that the courts are really trying hard. They have been trying hard for a number of years, and the trend continues now to send a very powerful message out to people who commit sexual harassment in the workplace. And in this case, I'm quite sure that had there not been this element of procedural unfairness, the court would have set aside the compensation award in its entirety. So it's another important piece in the sexual harassment jurisprudence, this time about compensation and when it might be appropriate to award compensation to an employee who has been found guilty of committing sexual harassment. Thanks, Graham.
Thanks very much for that, Nikita. We're going to move on to the second sexual harassment case, and this involves the issue of when an employer can be sued for not dealing with sexual harassment, or how they can be sued, in which forums, and the choices of action that employees have against employers. I'm going to hand over to Lusanda Raphulu. Lusanda is the head of our employment and benefits practice. And Lu, over to you. Thank you.
Morning, everyone, and thanks for joining us this morning. The first case that I'm going to be dealing with is PE versus De Beers Naudé Local Municipality. It's a 2021 High Court decision. It's a sexual harassment case, and in this matter, the employee took action against the employer in the High Court on the basis of unlawful conduct by the employer in dealing with her sexual harassment case versus taking the matter to the Labour Court. Just to give you some context in relation to the sexual harassment in itself, the employee was employed by the municipality as a registry and archives clerk. She was 23 years old at the time of the sexual assault. That was in November 2009. The sexual assault happened in relation to her immediate supervisor. So what happened is that she was in her office at the time, sitting down at her desk. He came into her office and bent over her and started kissing her and put his tongue in her mouth. She clenched her teeth to try and resist him. And she struggled to do that, but eventually after about a minute, she was able to. She was left with his saliva in her mouth, and she then took her hand to wipe it off. At the time that she did that, he also tried to wipe it off, so to take his hand and wipe it off her mouth, and she pushed him away. The municipality then had a hearing in relation to his conduct, The outcome of the hearing was that he was suspended for 2 weeks. And just to backtrack, before the hearing, when she went to report that this had happened, she was told that she was to take some time off before the hearing. So he wasn't required to be away from work, but she was required to be away from work and take time off and say that she was sick. And she was also required to report this to her immediate manager, who's the one who had actually sexually assaulted her. So she reported to him that she was sick, and he did not believe her, of course, knowing what had transpired between them. And he challenged the fact that she was alleging that she was sick. And she then offered to give him a sick note to prove her sickness. So this is just a bit of what happened before the actual hearing. So going back to the hearing is held, and the chairperson says the outcome is that she is heard and he's found guilty, and the outcome is that he is suspended for 2 weeks. At the end of the 2 weeks, he came back to the workplace. She would see him, she would have to interact with him. She found that she was struggling, that she was suffering from PTSD. She said that she struggled even to be in public outside of the workplace. And when she saw someone who almost looked like him, she began to feel scared all over again, and that it was affecting her on a day-to-day basis. She also found that in the workplace, her colleagues seemed to take his side, and she was seen to be a difficult person in the municipality. And one of her colleagues said that she brought bad vibes. So she then took this matter to the High Court on the basis of unlawful conduct by the municipality. The court was very scathing of the municipality for various reasons. The first being that the municipality didn't even have a sexual harassment policy in place. The second being that she was made to be away from the workplace before the hearing, and nothing was done in relation to him being required to be away from the workplace before the hearing. The third being the outcome of the hearing itself, that it was only a 2-week suspension, after which he came back to the workplace. The court said that the municipality didn't take seriously its responsibility to not only have a hearing because there were allegations, but after the hearing and the outcome being that the employee was found guilty, the municipality didn't take any measures in taking that seriously and trying to make its workplace free of sexual harassment. The court spoke about the importance of taking sexual harassment cases seriously, the power dynamics between individuals, the fact that it's usually a male in a superior position in relation to a female in a subordinate position. The court said that it wasn't enough for an employer to simply hold a hearing and then wash its hands and feel that because it had held a hearing, it had done its job. That an employer actually needs to make sure that the workplace is free of sexual harassment. The court was scathing in relation to the fact that the municipality didn't seem to be concerned about her well-being at all. She wasn't offered any counseling after the hearing. They never interacted or spoke to her about what had transpired ever again. They were not concerned about the fact that she continued to have to interact with him. They didn't seem to be concerned at all about what had transpired and had washed their hands of the whole thing. So she sued in the High Court in relation to the impact that this had had on her. She sued for approximately 8 million rand. And after looking at the different things that had transpired, looking at her past loss of income because of what had transpired and her resigning, looking also at future losses of income because of the impact of the sexual harassment on her, because of the PTSD, looking at the psychological impact on her and the psychological support that she needed and that she would continue to need. The court awarded her damages. The court also made a point of stating that as a municipality, They also had an additional obligation in terms of the Constitution. So not only an obligation as an employer, as an ordinary employer, but also that municipalities as organs of state also had duties in terms of the Constitution in itself in order to respect and protect the Bill of Rights. The court then, at the end, even though she claimed damages in total of approximately 8 million rand, awarded her damages of just under 4 million rand, 3.9 million. But the court was very serious about that. The principle here that employers must not only hold a hearing when there has been a sexual harassment case, but also take the responsibility of keeping the workplace safe and free for all employees, and to make sure that the employees are actually taken seriously and taken care of post a sexual harassment case. And that holding a hearing and then washing your hands, even if the hearing ends up in the outcome of the perpetrator continuing to be in the workplace, was unacceptable, and that the employer should have done something about that, and that holding a hearing in itself is not enough for an employer in taking its responsibilities in relation to sexual harassment cases.
Thank you, Lou. And I think the important principle being as well is that, victims like this can choose their forum. They can either, go to the High Court and claim on a delictual basis that you've breached your duty of care to me, and I've suffered damages, and those damages then become delictual damages like we saw in this particular case, or they can go to the Labour Court and sue through that mechanism using the Employment Equity Act. So, it's this choice of forum issue. And then just also on the choice of forum issue, I would like you also just to touch on the case of Kutu versus the Minister of Department of Justice and Correctional Services, which again deals with this issue of delictual damages caused by employers when they seek to take disciplinary steps against employees.
So in this case, the employee was charged with misconduct and called to a disciplinary hearing. He was found guilty at the disciplinary hearing. He then appealed that outcome and he lost the appeal. An outcome of that, though, is that the parties agreed to hold an arbitration in relation to the misconduct allegations. And an outcome of the arbitration was that he was found not guilty and he was awarded 24 months compensation. He then decided that because he was found not guilty at the end of the arbitration and awarded 24 months compensation, that actually this was a case of malicious prosecution on behalf of his employer. And therefore he took the employer to the High Court on the grounds of malicious prosecution. He said that his manager had put the charges to him on malicious grounds. He cited other cases in which the courts had dealt with issues like this on the basis of malicious prosecution. He raised as part of this a matter involving an employee who was part of the police, but the court distinguished that case on the basis that in that case, the employee did not even get to go to a hearing, and therefore that employee did not have any forum for dealing with being charged with gross misconduct, and then the charges falling away without going to a hearing and without being able to then clear your name at all. And in that case, not only had the employee been charged and then not gone to a hearing, but the employee had also been arrested. And then it turned out that actually there was nothing to those allegations. The court distinguished this case and said in this case, the employee had been charged. He had gone to a hearing, he had gone to an appeal hearing, there had been an arbitration. And so to the extent that the employee felt that on the basis of malicious prosecution, damages should have been awarded, those damages should have been raised by the employee either at the arbitration itself or through the labor courts because they had actually gone through the disciplinary proceedings. Differentiated that from an employee who didn't even get the opportunity to go to disciplinary proceedings. So it's important in the respect that the court considered and looked at the fact that the employee had lodged proceedings on the basis of malicious prosecution, but unfortunately the outcome was that the High Court said it didn't have jurisdiction to hear this, and that the proper way for the employee to have raised this issue was either at the arbitration or to have referred a dispute to the labor court. The High Court held that it didn't have jurisdiction to hear the matter.
What I think is also interesting about the case as well is that it is conceivable that an employee can bring a High Court case for damages where an employer acts recklessly in proceeding with discipline and suspension, and where there isn't a cause of action, that you may in fact cause harm by doing that, and that may be a delictual wrong that gives the High Court the power to award delictual damages, as was seen in the case that was distinguished from this particular case, which is interesting because obviously employees will be choosing fora where they can maximize the kind of compensation that they can claim. And you know, it's interesting that you can go to the labor court for the unfair dismissal and then go somewhere else for your delictual claim for the harm done to you by the employer in acting recklessly and not exercising a duty of care. So I think interesting issue on that as well. Thanks, Lou. We're going to then move on to always this tricky problem that occurs when an employer disciplines an employee for what looks like serious misconduct, and your chairperson, who is not a very obedient chairperson, then imposes a sanction that you don't like. They give them a final warning, or in the case like the sexual harassment case, they give a 2-week suspension, and the employer is dissatisfied with the outcome and wants a more serious outcome and raises this whole issue of, can you go back for a second bite at the cherry, raises the issue of double jeopardy. Nikita, I'm going to hand over to you to deal with the latest findings of the Labour Appeal Court on this whole issue of, can you reverse the sanction? Thank you.
Thanks, Graham. Yeah, so as Graham said, this case is really about whether an employer is entitled to interfere with a sanction imposed in an internal disciplinary hearing by a chairperson, and in circumstances where the employer's disciplinary policy and procedure doesn't allow for such intervention. So in other words, the policy would say that the chairperson makes the decision, and it doesn't leave room for the employer to accept or reject or interfere with that outcome imposed by the chairperson of the disciplinary hearing. And as Graham said, this case is quite interesting because it touches on the concept of double jeopardy and the second hearing, and there have been lots of controversial and sometimes conflicting judgments on this point. So in terms of the facts, it's quite simple. Mr. Bears was employed as a senior electrical foreman. He was charged with misconduct for failing to comply with the employer's lockout procedure, which seems to be some sort of procedure about equipment and what needs to be done with equipment. And so he didn't comply with this procedure. He was charged and called to a hearing where he pleaded guilty to the charge. And the chairperson found him guilty, but imposed a sanction of a final written warning and suggested or recommended that he undergo some training on this lockout procedure. So Mr. Bears then goes for his training, and he was directed to report for duty, and the employer seemed to accept this. But then a union, NUM, lodged a complaint with the employer saying that it had essentially not applied discipline consistently, because its members who had been found guilty of the same offense for not complying with the employer's lockout procedure had been dismissed. So it's quite interesting that the union here was actually calling for a dismissal based on the fact that its members were previously dismissed for the same conduct. So on the strength of this complaint, the employer then decided that it would conduct an internal review of the disciplinary sanction. It then decided to suspend Mr. Bears and constituted a review panel. They had another hearing, and ultimately they found that he was guilty and that he should actually be dismissed. And Mr. Bears was then dismissed summarily with immediate effect. He was, of course, unhappy with this, and he referred a dispute to the CCBA. And the arbitrator there actually said that the dismissal is fair. So the arbitrator was convinced that the employer was actually entitled to go back and interfere and effectively change the sanction from a final written warning to dismissal. On review in the Labour Court, the Labour Court found that the arbitrator's award should be reviewed and set aside because the employer had not established exceptional circumstances to interfere with the decision. So the Labour Court ultimately disagreed with the arbitrator and said, no, actually, the employer wasn't entitled to just go back and have another hearing and decide differently in circumstances where they didn't demonstrate that there were exceptional circumstances that required them or warranted them actually doing this. So on appeal, this matter really turns on the test to be applied here, and the appeal court had to consider when it would be appropriate for an employer to intervene in these circumstances. And the LAC referred to some of the previous judgments. In some judgments, the test had previously been recognized as one of fairness. So an employer could intervene and effectively change the sanction where it would be fair to do so. And other judgments actually refer to a higher threshold where the employer has to demonstrate exceptional circumstances to interfere. And ultimately, the Labour Court here said that the test is fairness, but fairness is informed by exceptional circumstances. So in other words, in order for an employer to say that they were allowed to intervene, they have to show that it was fair to do so in the circumstances. But in order to show that it's fair, they actually do have to demonstrate that there are exceptional circumstances that warranted its intervention in the sanction that's imposed. And on the facts here, the court said that there were no exceptional circumstances. The employer seemed to be happy and accepted the sanction of a final written warning until the union then lodged its complaint. And it's only when the union complained that the employer then decided that it wanted a more severe sanction. And also that the employer didn't introduce any facts that would establish exceptional circumstances to intervene. So ultimately, it was unfair for the employer to intervene and change the sanction, and the arbitration award was reviewed and set aside, and the dismissal was found to be unfair.
Thanks, Nikita. I just want to, in light of one of the questions raised by one of our audience members, go back to the McGregor case, but the question is, what were the procedural defects? I don't know if you know them, that gave rise to the compensation award of ultimately 2 months. I don't know if you're able to answer that.
Yeah, it's a good question. The judgment actually doesn't say what the procedural defects were in any detail, so it's really hard to assess what in our view would have been an appropriate award of compensation. But I think the court it was very clear that it wasn't egregious. I don't think it was to the extent that it prevented him from providing his defense and stating his case. It might have had something to do with a particular witness or some evidence not being introduced, but ultimately the court said it was immaterial. And it was really minor procedural irregularities that warranted a minor award of compensation. So fortunately, the judgment doesn't give us too much detail on that.
Thanks, Nikita. Right. We're going to just turn to the issue. It's a tricky issue that employers often have to deal with, is where you're trying to deal with an employee who is not performing to the standard required. And ostensibly, you're dealing with misconduct. But in dealing with misconduct, the employee then raises issues normally that I'm suffering from stress and anxiety, and it's my workplace that's causing me stress and anxiety, and that's why I'm performing poorly. So you're then faced with, are you dealing with an incapacity issue as opposed to a misconduct issue? And there are two cases that have arisen on this. And I'm going to hand over to Ros to deal with the first case of Minister of Justice and Correctional Services versus Khara. And then you'll move on to the Palanga case. Thank you.
Thanks, Graham. Okay, so this is an interesting case. In this case, the employee was employed as a security official, external custody. So what this meant was that his job entailed him escorting offenders or inmates when they left the prison. So whether they were going to court, the hospital, or a doctor, he was responsible for that. He'd been with the Department of Correctional Services for 17 years, and he had always had good performance, good attendance. So there'd never been problems with him. Unfortunately, the employee went through a divorce. as a consequence of the divorce, he was suffering from stress. It caused turmoil in his life, and he wasn't coping mentally. The employer was aware of this. In addition, he had sought the assistance of a psychologist, so he was getting help. But as a result of this, there were a lot of periods of absenteeism and late coming on his part. So he had received several warnings for his late coming, and 3 of those were in October. He took family responsibility leave, but when he was asked to provide proof of the family responsibility issue, he was unable or refused to do so. He was then given a verbal warning. A month later, he took sick leave. When requested to provide a doctor's certificate, he didn't do so, and he was given a final written warning. And a year later, or 8 months later, he arrived an hour late for work, and he was given a written warning. Now, during this period, the employer had tried to accommodate him. They'd changed his shifts, and they'd really tried to assist him. They'd also offered him assistance of the employee wellness program, but he had refused this because he was seeing his own psychologist. The problem then comes in the November and December. So this absenteeism issue had been going on now for over a year, and it had been addressed by the employer, but it wasn't improving. In the beginning of the November, he was given a final written warning, again for absenteeism. And notwithstanding this final written warning, there were 2 more incidents of absenteeism. And ultimately in December, he was charged with misconduct as a result of the continued absenteeism. The chairperson of the disciplinary inquiry considered that his long service in these circumstances was not a mitigating factor. The chairperson found that it was an aggravating factor, and the chairperson's reasoning was that as a long-serving employee, he should have been setting an example to other employees, and his continued absenteeism was unacceptable. The chairperson also said he was on a final written warning. The employer had followed progressive discipline, and this had been exhausted, and therefore decided to dismiss him. The employee, dissatisfied with his dismissal, referred the dispute to the bargaining council, and the matter ultimately ended up in arbitration. Now, most of the facts were common cause. So it was common cause that he was suffering from emotional strain. It was common cause he'd been through this traumatic divorce. It was common cause that he was seeing a psychologist. And it was common cause that he had been on these written warnings and he continued to be absent. The arbitrator, in considering the dismissal, found that this dismissal was substantively unfair only on the basis of the sanction not being appropriate. So the arbitrator said that the specific circumstances of this case should have been taken into consideration when coming to a finding on dismissal. And the arbitrator said of relevance there was his years of service and the fact that until his divorce he'd had good attendance, that he had accepted that he was battling and had psychological or mental or emotional problems, and he was seeing a psychologist to try and sort that out. And ultimately the arbitrator said the company could, although the department could have found an alternative by putting him on unpaid leave to give him an opportunity to get better and to improve. The arbitrator then overturned the dismissal and said, because he is in fact guilty of the misconduct, he should be given a final written warning and then ordered that he be reinstated without back pay. So the arbitrator then finds the dismissal unfair and reinstates him on these grounds. The matter is then taken on review to the Labour Appeal Court. And ultimately, the Labour Appeal Court, having considered all the evidence, finds that the arbitrator's finding falls within a band of reasonableness. So, this band of reasonableness is a very, very flexible test. And the Labour Court then upholds the arbitration award and dismisses the review application. The difficulties I have with this case really are that there seems to be a fudging between misconduct and incapacity, because the reasoning of the arbitrator is this guy was suffering psychological or emotional problems. He was seeing a psychologist. He was trying to sort it out, which in my mind puts the absenteeism into the incapacity realm, not the misconduct realm. But the arbitrator doesn't find that. He accepts that it is misconduct and he gives a final written warning. Now, if the employee is ill, a final written warning is not appropriate for an incapacity, in my view. It should be some form of process of consultation or assistance provided. But be that as it may, that is what the court found and what the arbitrator found. But it is an interesting case, and we are seeing more and more of these mental illness cases coming forward. So it is becoming more prevalent, and I suppose it really depends on how the employee goes about defending himself, whether it's a, look, I didn't commit misconduct because I'm ill, or yes, I did commit misconduct, but there are mitigating factors. The next case I want to discuss is Patlanga versus Petro SA. This case also talks to the issue of mental health issues and psychological trauma, or purported psychological trauma. So Mr. Patlanga was employed as a senior process controller by Petro SA. He was, however, a chemical engineer graduate. He was employed by Petro SA for 14 years, and it seems that he became resentful that he wasn't promoted to a position more suitable to his qualifications. And I think this caused a lot of friction. His role as a process controller or senior process controller was pivotal to the refinery. So his role included monitoring the operation of the refinery as a whole, and he had a panel that consisted of various monitors that he had to constantly watch. Now, the role was so important that the panel could not be left unmonitored. So the rules were that the person on shift could not leave his shift before the next person came in. So there always had to be someone monitoring these screens. Prior to the events leading to his dismissal, Mr. Patlanga had been found guilty of a lack of punctuality, unauthorized absence from work, and fraud. The fraud related to allegations that he had actually altered medical certificates by altering the dates on those medical certificates. Mr. Patlanga was found guilty, and he was placed on suspension without pay as an alternative to dismissal. He was dissatisfied with this and he referred a dispute, but ultimately the disciplinary action was found to be fair. The events then leading to his dismissal were as follows. In the July, it commenced with him being absent from work. So he was scheduled to work, and on the first incident, he got his mother to call in and say he wouldn't be coming to work. Now, the rules of the department were that you must call personally, you must speak to your employer, your supervisor, and explain the reason for your absence. So he didn't do that because he got his mother to call. The difficulty for the department was his mother called 10 minutes before his shift was due to start. So that put them in a very difficult position because now they had to find a replacement, and it meant that the person who was currently on shift could not leave and go home until a replacement or someone else had been found. So created huge difficulties for the employer. That evening, the employee, Mr. Patlanga, then phoned another colleague of his and said, look, I'm taking the day off tomorrow. I'm not coming in tomorrow either. Again, he did not speak to his supervisor, and he then did not go to work. The 2 days after that, he was not scheduled to work, so he remained at home. And then on the third day, when he was scheduled to come in again, he contacted his supervisor and said, I'm not coming in. So he'd now been absent for 3 shifts. At this stage, he'd given no reason for his absences. And ultimately, his employer sent him a letter instructing that he was required to report to work on a specific day, and that he was required to explain his absence and provide proof of the reason for his absences. And if he didn't report, his conduct would be viewed as insubordination. He still didn't report for work. He was then given a further letter informing him that he was also required to personally notify his supervisor of his absences. During the periods in question, he ultimately missed 5 shifts. He eventually reported for work, and he was informed that a disciplinary hearing would be held. At the disciplinary inquiry, he presented a document in which he made allegations that he admitted to the misconduct, he admitted to the absenteeism, but he gave this explanation that he was uncomfortable at work because of the interpersonal relationships at work in the product section. He said they were poor and this was affecting him psychologically. He also stated that people were trying to eliminate him from his job and that he felt trapped. He also said that he was a victim of discriminatory and racist verdicts, and in this regard, he was alluding to his suspension without pay. And ultimately, his explanation was, I was worried that if I came to work, I would have a psychological breakdown. And that is the explanation he gives. The chairperson of the disciplinary inquiry considers this and says he is guilty, and if this is misconduct, it warrants dismissal. But before I rule on dismissal, I want him to go and get a psychologist's report. And I want the psychologist to let us know if he was too ill and that was the reason for his absence. So if there was a mental health issue, or if there was another reason for his absence. He ultimately went to the psychologist, and the psychologist gave a report which largely reiterated his complaints, saying that he was being victimized, saying that people were out to get him, but didn't talk to his psychological well-being and didn't talk to the reason for his absence. What the psychologist ultimately concludes is that he should get assistance from a psychologist and that he should be considered for a promotion, because this seems to be his underlying concern was that he was working in a position that didn't recognize his qualifications as a chemical engineer. The chairperson reads the report and says, look, this hasn't answered my questions. I am satisfied he committed misconduct, and ultimately he is dismissed. One of the difficulties for the employer was that for the period between when the disciplinary hearing was held and his ultimate dismissal, he didn't report for work, and he was not paid for a period of about 5 months. Mr. Patlanga refers a dispute to the CCMA. In fact, it would have been, I think, to the bargaining council. He refers a dispute to the bargaining council, and he claims 2 things. Firstly, he claims it was unfair that he wasn't paid, and this really constituted an unpaid suspension, and that his dismissal was unfair. The arbitrator agreed and said, insofar as the unpaid suspension was concerned, and said the employer had no right not to pay him during this period and was ordered to pay him the 5 months. Insofar as the second claim was that he was unfairly dismissed, the CCMA considered his evidence and said the difficulties for Mr. Patlanga is he did not give a reason for his absences. So he comes with very vague allegations saying, oh, I was stressed and I was unhappy and I didn't want to have a breakdown. My colleagues have been putting pressure on me. People are trying to get rid of me. But he didn't say, I was incapacitated. And the arbitrator then weighed that up and then weighed up the pressure put on the employer and his colleagues by his continued absence in the light of the pivotal role that he played. The arbitrator also considered the doctor's or the psychologist's report and said, in the absence of the psychologist actually coming to give evidence, there's very little weight I can attach to this report. And ultimately, the arbitrator finds that the dismissal is fair. Dissatisfied with this, Mr. Pahlanga went to the Labour Court, and ultimately he says that the arbitrator erred because the arbitrator didn't recognize that the duty was on the employer to fully investigate if there were any reasonable alternatives to dismissal. And in this regard, it appears that Mr. Pahlanga was relying on item 10.1 of Schedule 8 to the Labour Relations Act, which deals with incapacity. Now, broadly speaking, item 10 provides that where an employee is incapacitated, the employer must investigate all possible alternatives to dismissal. The employee should be allowed an opportunity to state a case in response and to be assisted. The employer must consider the degree of incapacity, and particular consideration must be given to whether or not the incapacity was due to an injury at work or an illness caused at work. Now, Pahlanga contended that based on this, it was for his employer to fully investigate every alternative to dismissal, and that in failing to do so, his dismissal was unfair. The Labour Court says this is incorrect. And the reason for that is it was never Mr. Pahlanga's case that he was incapacitated. What he said was, I might have been incapacitated. I might have been incapable of performing. He doesn't actually come and say, I wasn't. And the Labour Court said it's not for the employer to eliminate all possible explanations. In the event that an employee finds or feels that there is a reason that he is not guilty of misconduct, that employee must put forward that reasoning and must come forward and say, I am ill, I am incapacitated. And until that time, unless there are objective facts that make the employer aware of some form of illness, then it is not the duty of the employer to do so. And objectively, the employer was justified in dismissing Mr. Pahlanga. So interestingly, even though the chairperson went down the route, the chairperson took the extra step to investigate whether or not there was an incapacity. The Labour Court said that that was sufficient, and it wasn't for the employer then to say, well, can we accommodate this employee further? And ultimately, it was apparent that what Mr. Pahlanga was doing is he had a grievance. He was unhappy with the fact that, with his position, and with the fact that he wasn't promoted to a position equivalent to a chemical engineer. And that was really the cause of his dissatisfaction. The court also said it was noteworthy that he didn't lodge any grievances. He didn't raise any concerns about the so-called ill treatment, about the fact that he was being discriminated against. He also didn't take the finding that his previous disciplinary action was fair on review. So he appears to have accepted it. So this was one of the cases where, once again, there seems to be a bit of a blurring between misconduct and incapacity, but it made it very clear that there must be some objective basis for an allegation of incapacity. You can't simply say, well, I might have been incapacitated. I am feeling stressed. You need, as an employee, to say, I was stressed. This is why I'm stressed. I was physically ill and I could. And that is that case. So thank you very much.
Thanks, Ros. One of the questions that's come up is whether the chairperson of a disciplinary inquiry is within their rights to direct parties on what evidence to lead in order to give his verdict or even to determine sanctions. So in other words, if a chairperson is listening to evidence and the person comes up with the story of incapacity, whether the chairperson could actually say, we'll go off and see and get a psychological report. Your sense on that, Ros?
Sorry, just taking mute off. Look, essentially, the chairperson acts within the scope of their mandate. So, you know, you've got terms of reference generally as a chairperson. However, I would caution if something like that were raised. If I were acting as the chairperson, I would err on the side of caution. I don't know whether that would give you permission, the power to say you must do this. But I think that making a recommendation, requesting that the parties investigate further, can only be in the interests of fairness. I mean, ultimately, I think the employer, or the requirements on employers are that they must act fairly. So if there is such an allegation, I personally would recommend that it be investigated, unless it was so blatantly obvious that it was just a ploy. So that is just a sense of fairness issue from my perspective.
No, I think it's also worth bearing in mind that we don't apply strictly the accusatorial system in dealing with disciplinary inquiries. The whole thing is around fairness. So if the chairperson does believe that further evidence is needed, I think they are within their rights to direct that further evidence be given, particularly if an employee then is defense is incapacity. And I was, you know, I breached the rule, but the reason why is that I'm incapacitated for whatever reason. I think there's almost then a duty to go further. Let's then move on to the latest case on discrimination. And it's a question of, you know, whether your employer can require you to speak Mandarin in the workplace. And I'm going to hand over to Lenya, who is our newest partner in the employment and benefits practice. Thank you.
Thanks, Graham. Good morning, everyone. So the case that I'm going to discuss today is Davey versus Metarex, which was a dismissal case based on unfair discrimination that went all the way to the Labour Appeal Court. So the factual background was that Mr. Davey was employed as Chief Operating Officer of Metarex, which is a mining company based in Johannesburg with operations in Zambia and the DRC. The mines were in severe financial stress, and the majority shareholder of Metarex's holding company was a Chinese company called the Jinchuan Group, which I'm going to call the J Group for ease of reference. What the holding company did is that they took over the day-to-day operations and management of Metarex and implemented what was known as the J Group silo model. In doing so, the J Group replaced the local general managers at the mines in the DRC and Zambia with Chinese-speaking nationals. And this had the effect of changing the role of managerial staff at the Metarex head office in Johannesburg to be more supervisory in nature. The newly appointed GMs also reported directly to a new acting CEO and a newly introduced acting deputy CEO, both of whom were Chinese nationals. Mr. Davey, as a local Joburger, raised a grievance against his role as Chief Executive Officer having been made redundant by the new management and reporting structure, but it wasn't resolved. After some time, Metarex issued Section 1893 letters to all of its head office staff in Johannesburg, including Davey, and retrenchment consultations commenced. Davey disputed the need for his retrenchment and argued that his duties and responsibilities as COO had been usurped on the basis that they had been collapsed into this new position of acting deputy CEO, and that his position had not actually become redundant. He proposed that instead of retrenching him, he be promoted into the position of deputy CEO, since firstly, he was a much better candidate for the position and he had a longer service record with Metarex than the Chinese incumbent. This proposal wasn't accepted by the company and Davey was subsequently retrenched. So Davey went on to refer an unfair dismissal dispute to the CCMA, alleging that his dismissal was automatically unfair, alternatively substantively and procedurally unfair. And the main basis for his claim of an automatically unfair dismissal was that he was discriminated against because he was not a Chinese national or a Chinese-speaking person. The dispute wasn't resolved at the CCMA and was referred to the Labour Court for adjudication on the basis that it was an automatically unfair dismissal claim. So when it went to the Labour Court found that Davey's dismissal was not automatically unfair and that the implementation of the J Group silo model had resulted in redundancies including the position of Chief Operating Officer. The court didn't understand De Bruyn's case to be that the position of COO still existed, and accordingly they found there was no logic in having De Bruyn in a position that didn't exist. The Labour Court also held that the more likely cause of De Bruyn's dismissal was that his position had in fact become redundant and not on any discriminatory grounds. His selection for retrenchment and non-appointment to the position of acting deputy CEO could not solely be reduced to his not being a Chinese national. On this basis, De Bruyn's dismissal was neither automatically unfair nor unfair. Again, De Bruyn wasn't happy with this decision and took it on appeal to the Labour Appeal Court. In the Labour Appeal Court, De Bruyn persisted with his argument that there had been unfair discrimination against him on the basis of race, ethnic and social origin, culture, or language, and that his dismissal was automatically unfair. De Bruyn testified that Meterex had appointed the acting deputy CEO to displace him and replace him with a Chinese national. In the hearing, a concession had been made by Meterex that De Bruyn would not have been retrenched had he been Chinese speaking. But what the Labour Appeal Court held was that this concession had to be understood in the context of all of the evidence that had been presented, and that the legitimacy of the business rationale for appointing Chinese-speaking mine managers and a Chinese-speaking CEO could not be rebutted. The substantive reasons for the appointments related to the language and culture, and Meterex had found itself in an extremely serious financial circumstance where something had to be done to save the company. The Labour Appeal Court confirmed that the evidence pointed to the fact that De Bruyn was terminated because his position had become redundant. So at all times, they were looking at the proximity of the reason for the retrenchment. And his redundancy had arisen as a result of structural changes effected for operational and financial reasons. What the court found was that the ability to speak Chinese had essentially become an inherent requirement of the job to facilitate direct communications with the GMs based at the mines, Chinese shareholders, and with Chinese financial institutions. So retaining and promoting De Bruyn would have imposed undue hardship for Meterex, who was already in severe financial distress. So there was no fair discrimination. And then on the issue of substantive fairness, the Labour Appeal Court found that De Bruyn's desire to be promoted to a higher position simply because he had a longer service history with Meterex and because his duties as COO had been assimilated into the position of Deputy CEO was misplaced because he had never claimed that he had the requisite experience to act in a position of Deputy CEO or experience of the J Group silo model that had been introduced. So on that basis, his claim was dismissed on all counts. Thanks, Graham.
Thank you, Lenya. Thanks very much. I just want to pick up on one or two of the questions that are asked, and principally this goes to the double jeopardy issue, Nikita. So the question that's asked is whether if an employer wants to reverse a sanction or have another bite at the cherry, as we put it, are they obliged to take it on review to the courts, or do you just do it through the internal processes?
Yeah, thanks, Graham. Interesting question. In terms of this judgment, it was quite clear that Anglo, the employer, had actually established an internal practice of conducting an internal review of the decision. And that was actually upheld through all the courts. The only problem that the court ultimately had was that in this case, the employer wasn't actually able to show that there were exceptional circumstances for interfering. So the court didn't have a problem with the employer revisiting the decision internally. And that seems to suggest that employees don't have to go to court to review the decision, but can actually do so internally, but they have to show exceptional circumstances in order to do that, and in order to prove that it's actually fair to change the sanction.
Thank you. Then a second question arising out of that is that what happens if you've got a collective agreement with your majority trade union that is your disciplinary inquiry? So your disciplinary process is the product of a collective agreement. And that collective agreement has the right, obviously, of an employee to appeal against a sanction, but no right of an employer to appeal against the sanction. Would you be breaching the collective agreement if you try to then have a second bite at the cherry?
All the difficult, interesting questions. I think, firstly, this case, the Anglo case, also showed that in that case, the employer didn't have a mechanism in its policy to review the decision internally. And that's why you have to demonstrate exceptional circumstance. So even if your procedure is effectively contained in the collective agreement, you would still be allowed to show exceptional circumstances in order to review that or change that decision. So it doesn't matter that the collective agreement doesn't allow for it, because that effectively becomes your disciplinary procedure. But so long as you still have exceptional circumstances and you're able to demonstrate that it's fair to change the sanction, that would be fine. Separate question, there's a slightly different question about whether or not that constitutes a breach of the collective agreement. I think that would be an attractive argument for a union. But I think that on balance, if the employer could show that there really were exceptional circumstances, then it was fair to do it. I think that might be okay, but obviously breach is a different cause of action. So I'm actually not aware of any case that decided it on that basis. That would be quite interesting. I think my sense is that the employer would come out okay there. But, you know, the union would really have to show that it was a breach and the employer really wasn't able to do that.
Thanks so much, Nikita. So I want to just inform the audience that there is another seminar coming up on the 22nd of September dealing with the issue of employment in business rescue proceedings. You may have seen that quite a lot of companies have unfortunately gone into business rescue as a consequence of the COVID crisis. So SAA comes to mind, Comair comes to mind, Mango comes to mind. Those are all the airlines, but there are others as well. And what we've seen is a flurry of court cases about business rescue practitioners trying to retrench employees and when they can and when they can't, and whether they've got to wait for the ultimate outcome of a business restructuring plan before they are able to do the retrenchment exercise. So a very interesting topic. It's coming up on the 22nd. I think Roz is one of the speakers, Nikita is one of the speakers. So if you're interested, Simon will share the link with you and you're welcome to join. But that then brings us to the end of our program. We finished 15 minutes early, which I don't think is a problem. We can all go have some coffee. Thank you very much once again for your participation. We look forward to seeing you at the end of the year for the final catch-up. And hopefully, again, we will have a series of interesting cases to entertain you. Thank you very much for your time this morning. Thank you to the panelists and chairs. Thank you.
Thanks, everyone.
Everyone.
Thank you. Bye-bye.